Did you know? Episode 3, Part 4. Because the 2014 U.S. Supreme Court ruling in the Hyen versus State of North Carolina case, it is a perfectly legal defense for police to plead ignorance of the law. 5 reasons highlight the inconsistency of the court's mistake of law analogy within the context of the Fourth Amendment compared to the criminal law mistake of law defense. Reminder what our Fourth Amendment says. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Firstly, the court's allowance to the officer's legal ignorance results in an imbalance between law enforcement officials and the general public. While ordinary individuals are held accountable for their lack of legal knowledge, the court diverges from established criminal law principles by permitting the officer who is tasked with enforcing the law to utilize such a defense. Secondly, the Hyen Court's introduction of reasonableness standard in evaluating whether an officer's ignorance or mistake of the law should be excused stands in contrast to criminal law where reasonableness is not considered. Thirdly, criminal law allows a mistake of law defense solely when the defendant has based their actions on an official interpretation of the law. But the court accepted an officer's mistake of the law claim based solely on the officer's personal interpretation. Fourthly, the court overlooks the criminal distinctions between an officer invoking a mistake of law defense to avoid evidence exclusion and a defendant invoking it to prevent criminal liability. Defendants are granted this defense because a criminal conviction could threaten their freedom, assets, and dignity, as well as lead to additional collateral repercussions such as job loss, disappearance of benefits, and denial of voting rights. Conversely, an officer only faces the possibility of evidence being omitted. Fifthly, the court undermines the rule of leniency by failing to pinpoint any ambiguity in the law prior to ruling in favor of the officer's interpretation. Typically, the rule of leniency necessitates that any unclear laws be construed in the defendant's favor. What are your thoughts on law enforcement having the option to claim a misunderstanding of the law while citizens are expected to be aware of it? Share your opinions in the comments. Stay tuned for episode 3, part 5. If you missed episode 3, parts 1 through 3, be sure to go back and watch those posts. Until we meet again, my goal isn't to make you feel at ease. I aim to present the truth, inspire critical thinking, and challenge your preconceived notions.